Hello, everyone. I hope everyone is doing fine, and welcome everyone to the book launch of Doing Justice to History by Barrie Sender. This event, I must mention, is co-sponsored by the Grootjes Dialogue and Justitia, which is LUC's International Justice Committee, of which I have the honor to be chair this year. Today we'll be listening, of course, to Barrie Sender himself, who is an assistant professor of international justice at the Leiden University College. We will also be listening to Gary Simpson, who is chair in public international law at the London School of Economics. He has also been teaching at the University of Melbourne and the Australian National University. He also wrote the prize-winning book Great Power and Outlaw States. In addition to that, we will be listening to Larissa van den Herk, who is a professor of public international law at Leiden University and who is also the editor of the Cambridge Studies in International and Comparative Law and the general editor of the Leiden Journal of International Law. So a lot of interesting people to hear from today. And how this will take place today, we will, Barrie will first open with a presentation of the book. This will then be followed by reflections of Gary Simpson and Larissa van den Herk, to which Barrie will offer a response afterwards. After that, there will be time for everyone to ask questions and to have reflections. So there will be time for that at the end. And then I will now give the floor to Barrie to give his presentation on the book.
All right. First of all, thank you, Yasmin, for that very kind introduction. And actually, I do just want to begin with a few thank yous more generally. So, because this has been, a very long process. I want to begin by, first of all, thanking Justitia for hosting the event today, also Grotius Dialogues for co-sponsoring the event, and Leiden University College. I want to thank all the universities that have been part of my kind of journey with this book. So most obviously the Graduate Institute in Geneva, which is where I did the PhD on which the book is based. But also I spent a bit of time at Harvard, University of Copenhagen, and FGV Direito Rio in Brazil. A very special thank you to my PhD supervisor, Professor Andrea Bianchi, who really shaped the way I think about international law in a considerable way, and this project would not have been possible without him. I want to thank my discussants today. Professor Gary Simpson, who had the good fortune, I hope, of being the examiner on the PhD of which this book formed a part. Gary gave me the good advice of, he said, write the book immediately after the defense. And of course, it took me a further 3.5 years to actually get the book out. So I didn't exactly follow that advice directly, but hey, here we are. And I want to thank Larissa van den Herk. And, it's quite special because Larissa's course on international criminal law at the University of Leiden was really my first point of contact with international criminal law back when I was a master's student. So I'm like, I don't know how many years ago, it's like 14 years ago or something. So it's very special to have you here. And I know we've had conversations in the past about these issues. So it's lovely to have you here with us today. And then I want to thank, my family, my parents in particular, who have been constant support, but also my wife, my daughter. And thank you to everyone who has shown up to this event. I was worried that no one would show up. Fortunately, there are some people in the room, so thank you for coming to listen to me. Now, I am aware that not everyone will have read the book, and probably no one actually so far, except maybe the discussants. So what I've done is I've put a bit of a presentation together, and really the aim here is to give you a bit of a snapshot of the book. Just to give you a sense of what my main arguments are and what it's about. So can you see the presentation? Is it showing up? I hope so. I try to choose a bit of a jazzy style to make it easy on the eye. So let's begin. I also have a physical copy of the book with me, which is exciting. So yeah, let's begin with some background. So the background, what I really want to do is I want to start by looking at what were the points of departure for this project. And really there were two points of departure. So I started writing this project in 2012. And at that point in time, the field of international criminal justice was somewhat at a crossroads. Institutionally, there was a sense that the field had exceeded all expectations. There was a degree of judicialization that few had thought imaginable just 2 decades prior. You had the UN ad hoc tribunals, you had the permanent ICC, you even had some hybrid tribunals. So there was institutionally a lot going on. But normatively, there was a sense that the field was failing to fulfill the wide-ranging ambitions and aspirations that had been invested in it, whether that be justice for victims, deterring crimes, reconciling divided communities. And this triggered considerable questioning of the faith placed in international criminal courts, questioning their identity, their meaning, and their purpose. So just to pick one article out from amongst many, Merjan Damaska wrote an article called "What is the Point of International Criminal Justice?" Right? You're really thinking these questions through. And then later, some years later, we have Christine Schroebel-Patel's volume on critical approaches to international criminal law, which really dug into the kind of what are the underlying assumptions of this field, and are they robust, and are they valid, and do they make sense? And so this was one starting point. And it seemed to me that whatever else international criminal courts were doing, it seemed clear that they were performing a historical function. History was being contested in their trials, history was being narrated in their judgments, and historical materials were being archived in their archives. So that was my first entry point to this project. But there's another entry point, which is once I started thinking about this idea of the historical function of international criminal justice, I realized actually there is a much longer debate that has been going on in this sphere. And scholars have actually been contesting the question of the extent to which criminal courts should engage in the writing of history for some time. So this goes back to, for example, Hannah Arendt's book, where she puts forward, the idea that the purpose of a trial is to render justice and nothing else. Even the noblest of ulterior purposes can only detract from the law's main business, which is to weigh the charges against the accused, to render judgment, and to mete out punishment. This very kind of narrow idea of what a trial is supposed to do, and really, a kind of pure idea of the criminal trial form. But then a range of scholars have challenged this position. Lawrence Douglas, Mark Ossiel, really looking at the didactic nature of criminal trials and atrocity trials in particular. And, in some instances arguing that, for example, domestic atrocity trials should be allowed to paint history with a broader historical brush, widen the historical frame, really embrace the fact that these trials are about history. And then we have a book, which I think Gary Simpson may recognize there because it's his, which I want to add on this slide because I think it was one of the first times where I saw the shift. There was this debate going on about should criminal courts be engaging with history? And I think Gary is one of the earliest scholars to say, okay, that's an interesting debate, but what are the histories that are actually being constructed in international criminal courts? Whose histories are being made to matter? And there's a really interesting chapter in Gary's book, which deals with that. And so, this debate was the second kind of point of departure for my project. And so what is my project? Well, my project is set against this kind of climate of self-questioning and discomfort in the field of international criminal justice. My project was to see if it was possible to understand international criminal courts, to understand what they are, what kind of justice they render, what functions they serve, what are their emancipatory limits and potential, to understand international criminal courts through the prism of their historical function, exploring in particular how such courts confront the past by constructing history concerning both the culpability of the individual on trial and the broader mass atrocity context in which they participated or alleged to have participated. And so really my project boils down to these two questions. Whose histories are being narrated in international criminal courts, and what histories are being narrated, what's being included and foregrounded, what's being marginalized and excluded. And through examining these questions, my book aims to provide a deeper understanding of the emancipatory potential and limits of international criminal courts. Now, at this point, I just want to take a step back and say one additional thing as by way of introduction, which is I think it's important to reflect a little bit on my positionality in relation to my research. So I'm a white male from the United Kingdom. I was born and raised in London. I have a Jewish background, and it was actually my Jewish background that first drew me to the field of international criminal justice. I was particularly interested in understanding the reasons behind mass atrocities, how individuals become drawn into them, and how societies respond. Now, the reason I'm raising this is because I think it's important to recognize that we always speak from a particular place and that all knowledges are always situated. And actually, this is something I was discussing in class with some of my students this week. So when I read the material to construct this book, I will have foregrounded and marginalized and excluded particular aspects of the field. So although my aim was one, I guess, in a sense of description, it's important to recognize that description is always inevitably political. It's always the result of my situated choices. And I think that's, really important to get that out there before moving on. Okay, so enough background. Let's get into the meat of it. What's my method? How did I go about this? Well, I focused on 3 sets of courts, the Nuremberg and Tokyo tribunals, the UN ad hoc tribunals, so Yugoslavia, Rwanda, Sierra Leone, and the Permanent International Criminal Court. And really, I was focusing on the judgments. I was looking at how history was constructed and what histories were included and marginalized in the judgments of these tribunals and courts. Now, for the purpose of examining the historical narratives within these judgments, my project relied on 2 presuppositions. First, the idea that judicial narratives are constructed, by which I mean they are always the product of the situated choices of the different actors who interact within international criminal proceedings. And so I've kind of done this in a diagram form here. It's quite simplified, but what you can see is that history flows through the entire proceedings in international criminal processes. And it's contested along the way. It's contested within the courtroom, and then those contestations actually are emitted outside the courtroom to audiences beyond the courtroom where there's further contestation of those narratives. So the first presupposition is that judicial narratives are constructed. And the second presupposition is that judicial narratives are inevitably forms of legitimation. They inevitably foreground some things, marginalize other things, include some things, exclude other things. So the question is not whether judgments legitimate, it's what they legitimate, how they legitimate, and what type of justice emerges because of that. Okay, final point on my methodology is that to examine whose histories and what histories matter in international criminal judgments, I relied on a framework. And that framework identified the actors involved in contesting history. So this ranges from prosecutors, defendants, and victims to judges, NGOs, and states. I looked at the questions around which historical contestation tends to be structured in international criminal justice processes. So it tends to be structured around persons, which individuals are targeted for prosecution, crimes, which categories of crimes fall within the jurisdiction of a court, how are those crimes understood, which crimes are charged, and finally, culpability. What categories of culpability are relied upon in the forms of modes of participation, defenses, to attribute, exclude, or mitigate the responsibility of the individuals on trial for the commission of crimes. And then the final aspect of this framework is I really wanted to dig in and look at the practices of these different actors contesting these questions. And when we think of practices in international criminal justice processes, we can think of practices that relate to evidentiary materials, so the collection of evidence, the admissibility of it, how it's scrutinized and evaluated. But we can also think of legal practices, practices which relate to legal categories, how these categories are drafted, interpreted, and charged in particular cases. Now, the focus of my book was really on the legal practices. So there has been important work done on evidence and fact-finding. Nancy Coombs's book stands out as a particular example of that. I really was interested in how history is kind of filtered and interacts with legal categories, and how different actors contest the drafting, interpretation, and charging of those categories, and how that affects the narratives that are produced in international criminal judgments. Okay, so far, so good. So that's the background and the methodology. We're almost there. So the next thing I want to do is give you a very brief overview of kind of the roadmap the book takes in conducting this analysis. So the first couple of chapters I really set in the introduction and the framework that I've just relayed to you. Then really the core of the text, chapters 3 to 5, I look at each of those questions around which historical contestation tends to be structured. So in chapter 3, I look at which situations have been targeted for investigation and which individuals and categories of individuals have been targeted for prosecution. Because obviously who is targeted shapes what stories are told. Chapter 4 looks at the crime question. So here we're looking at which crimes fall within the jurisdiction of these courts, which crimes were charged in particular cases, and how those crimes were interpreted and understood in practice. Because again, which crimes are looked at determines the focus, the scope, and the content of the histories that are produced. And then in chapter 5, we look at the culpability question, which is looking at how responsibility is attributed, excluded, or mitigated according to the categories of culpability, so modes of participation, defenses, and situational mitigating factors. So all of those chapters kind of show and try and reveal the different choices and the different types of histories that are included and excluded in practice through those questions and through those contestations. Then in chapter 6, I take a step back and I look at 3 dimensions of mass atrocity context that have been consistently diminished or excluded from the narratives of international criminal judgments. So here I look at structural and slow forms of violence. I look at the interventions of international actors, including the practices of colonial powers, international financial institutions, and international peacekeeping forces. And I look at the roles performed by bystander communities, a lot of communities who acquiesce in the violence in mass atrocity situations, and also resistors and rescuers who exercise agency during episodes of mass violence. And I show how these actors and experiences and narratives consistently lie beyond the purview of international criminal judgments. And then in the final substantive chapter of the book, I look at what I call historical narrative pluralism. So having explained what's included and excluded, marginalized and emphasized, I then look at how actually, although we often think of judgments as final, in fact, the historical narratives that are constructed in international criminal judgments tend to be neither static nor final, but actually subject to a process of ongoing contestation and evaluation and evolution over time, both within the courtroom in later judgments or in different courts, and beyond the courtroom when those narratives from the judgments are actually contested by actors in different contexts beyond the courtroom and filtered by all kinds of actors in different spaces. So that's a snapshot of the structure. And really the last thing I want to sort of talk about are what are the key claims that I end up making in the book? What are the key kind of findings and sort of takeaways, if you will? And so a cluster of my claims really revolve around this legitimation function of international criminal judgments. And really what I show is I try and show that there are 3 forms of legitimation that occur in international criminal judgments that stand out. So firstly, the histories that are produced tend to be apologetic histories. they tend to be constructed and restricted in significant respects in accordance with established relations of domination that exist both between and within states in the international political order at any given moment in time. And this is revealed most clearly in, if we look at the prosecutorial targets question, the silences of international criminal courts. So we have very clearly allied personnel who are excluded from prosecution at Nuremberg and Tokyo. We have NATO personnel who were subject to minimal scrutiny by the Yugoslav tribunal, members of the Rwandan Patriotic Front who were not prosecuted at the Rwanda tribunal, and factions that aligned with referring entities at the ICC, states that refer situations to the International Criminal Court that tend also not to be looked at by the prosecutor there. And what this means, what I argue, is that whether it's because of formal restrictions on the jurisdiction of international criminal courts, as in Nuremberg and Tokyo, or it's just by the exertion of informal pressure through the obstruction or selective provision of evidence, the balance of power between and within states beyond the courtroom has profoundly influenced the content, the focus, the orientation of historical narratives constructed within it. The second takeaway is that this histories produced by international criminal courts tend to be spectacular histories. They've primarily focused on the adjudication of a narrow set of egregious, physical, direct, and immediate forms of violence, to the exclusion, on the whole, of economic, social, and cultural forms of violence, as well as structural and slow forms of violence. Now, to some extent, this is an act of choice on the part of prosecutors, and Evelyn Schmid has done great work showing that actually some doctrinal tools do exist to bring these types of cases. But also, it is also a result of restrictions in the jurisdictional frameworks. Sometimes certain types of harm do not fall within these categories of crime, or certain entities, such as corporate entities, fall outside the jurisdiction of a court. But also, it's partly a result of the legal form of international criminal law, right? Which really focuses on this idea of intent, which sits awkwardly with the idea of structural and slow forms of violence. And so what I argue is that the risk is that absent other societal mechanisms for confronting and addressing these other forms of violence, international criminal judgments may serve to reassure, console, and soothe audiences by focusing on what they classify as the exceptional actions of a handful of individual perpetrators of spectacular forms of violence, whilst at the same time naturalizing the chaotic social, economic, and political structures that create the conditions of possibility for atrocities to occur in the first place. And my final point here is that international criminal courts, and in their judgments, they also produce narrow histories, or perhaps better, selectively contextualized histories. And they do this in two senses. First, in terms of actors and geographical space. International criminal courts predominantly examine the behavior of political and military figures within localized systems of criminality, whilst affording limited space for examining the behavior of economic business actors and broader international networks and structures implicated in mass atrocity situations. So here we have, for example, private security firms or illicit arms and diamond trade networks, international peacekeeping forces, or colonial actors. But secondly, they're also narrowly contextualized in terms of human agency. International criminal courts tend to emphasize how the collective and systemic dimensions of mass atrocity environments may expand the agency of the individuals on trial, whilst affording limited space for critically reflecting on the widespread societal acquiescence that characterizes mass atrocity situations, the dilemmas and ambiguities of agency experienced within these situations, or the possibilities that may exist to exercise agency and build solidarity to resist such passivity, conformism, and authority structures. So taken together, the apologetic, spectacular, and narrow nature of the histories constructed within international criminal judgments reveal a somewhat ironic picture. Courts promoted as mechanisms to challenge denial have risked becoming forms of, selective or partial amnesia. And so in the final move in my book, I then say, well, okay, so what do we do about this? What's the way forward? Is there a way forward? And in the final part of the book, I elaborate two perspectives that may potentially open up avenues for orienting the practices of international criminal courts towards a more emancipatory politics. The first is what I call strategic expressivism, which is the idea that actors may be able to use, if we move away from the judgment and the specific outcome of a trial, actors may be able to use other aspects of the international criminal justice process as one limited tactical component of their broader strategy for socio-political change. So they could use it to gain information, which they can use in other venues, or they can use it to gain publicity for certain atrocities, even if there isn't much hope held out for the prosecutor to bring a case against a particularly powerful actor. There are still useful things that can come from the process itself. And secondly, I argue that rather than expecting international criminal courts to deliver improbable moments of historical closure, I suggest there's a need for greater critical contextualization of the narratives constructed in their judgments, whether by looking backwards to the process through which the narratives were constructed, looking forwards to their ongoing contestation both within and beyond the courtroom, or looking sideways at other societal mechanisms tasked with constructing atrocity narratives about particular episodes of mass violence. So rather than mechanisms of narrative closure, international criminal courts should be viewed in more modest terms as, at best, a discursive beginning for individuals and communities to engage with and debate the past. Okay, I've spoken for a good 20 minutes there, so I will be quiet, but hopefully that gives you a sense of the book. And I very much look forward to the conversation that we're about to have. So thank you very much for listening to me. And I will stop sharing my screen. There we go.
Then we will listen firstly to the reflection of Gary Simpson.
Well, thank you, Barrie, for that. And I'll come to Barrie's book in a moment, but I want to, instead of offering a history of Barrie's book, I'm going to offer a little history of history, just for the first couple of minutes. And it begins with a sort of reflection on impunity itself, which I understand as international law's sort of state of nature. Another word for this is sovereignty. And Malcolm Bull, the political theorist, once said states didn't mind their citizens dying as long as another state didn't do the killing. So impunity was the rule of international law. And if there was any international criminal law, it was a law of impunity. And one gets a sense of this in, say, the treatment of Napoleon after the Napoleonic Wars. His time on Elba, almost a too merciful interregnum, was a form of impunity that represented also a mode of sophisticated politics. But more than this, if a reader picks up, say, a history of the Concert of Europe and reads its passages on war crimes trials, well, such references are simply not there. Nobody, bar a handful of bloodthirsty Prussians, was interested in trying Napoleon for atrocities or invasion. So when I came across some documents emerging from the Congress of Vienna, my initial impression was that these read as if they'd been edited in some way. There are ellipses where there should be trials. Instead of thunderous calls for retribution, we have a sort of gentler language of diplomatic nicety. And I'll quote, "The object of this union is as simple as it is great, calm and consistent in its proceedings. It has no other object than the maintenance of peace." So there are no thoughts of war crimes trials here in 1815. The high point of impunity, but perhaps also a turning point, came when Hitler celebrated and then in a way provoked the end of this impunity with his famous question, "Who remembers the Armenians?" And this was more or less the sort of amnesia, to use Barrie's word, demanded by the Treaty of Munster back in 1648. And I quote, "that there shall be on the one side and the other a perpetual amnesty or pardon of all that has been committed since the beginning of these troubles, so that all that has passed on one side and the other during the war shall be buried in eternal oblivion. International law then was, to restate the point, the law of oblivion. But since then, it's been history and memory all the way down, or at least since 1919 and the Treaty of Versailles. And I can't emphasize enough what a major shift this is in our ways of thinking and seeing and doing international diplomacy. Which brings me neatly to Barrie, who may be wondering when he's going to enter this story. I had the pleasure of examining his thesis several years ago, as he said, and I can still see the appalled response of his mother in the room in Geneva when I began with my customary trilogy of devastating critiques. So I'm not going to make that mistake. Not that I think that your mother's here, Barrie, at the moment, but I'm not going to make that mistake today because a book launch, unlike a Viva, is supposed to be a celebration, not a critique. And I have very little to critique in any case. I'm just delighted to have this book in my hands. It's a significant contribution to international criminal law and indeed the whole broader questions of memory and judgment. And it might be useful to place this work in a number of different contexts. So first of all, it belongs in our, well, what I'm calling at the moment our turn to turns. International lawyers are always turning to something or other, and our latest turn seems to be a turn to history, or at least thinking about history and how we might write our histories. It's really, the concern here is about how we might construct histories of international law. Of course, Barrie's turned that question around a bit and asked how international law lawyers or international criminal lawyers or international criminal courts are constructing history. But the history of international criminal law, which is a topic I teach at the LSE in one of my classes, really has two different meanings. This phrase, the history of international criminal law, has this sort of standard meaning of telling the history of the field from, I don't know, from piracy through to Kampala or from Nuremberg to Rome. Some sort of history in which lots of things happen in international criminal law. But the history of international criminal law also has the second meaning, which I take to be more provocative. And it's more of a historiographical meaning. And it's the one that Barrie is more interested in. And it's about the history that international criminal law itself produces. And as I say, this seems to me quite a seductive enterprise for international criminal law to be engaging in. Barrie's also making a contribution to the debate about impunity, to go back to my earlier comments, and anti-impunity and anti-impunity. And he's sort of positioned himself somewhat in what I'm thinking of as the anti-impunity group. He's somebody that's come along, not quite in the Karen Engel, Tor Krever manner, but somebody who's come along and begun to worry about the effects of certain aspects of international criminal law, but in a sort of atmosphere of friendliness. He's a sort of friendly interlocutor for those who work in international criminal tribunals. And I actually regard myself as very much part of that idea too. I must say, becoming slightly fed up of the critique of international criminal law. And I think what we need more is this sort of friendly engagement, this critical but friendly appraisal of some pretty difficult work that's been done by both practitioners and scholars of international criminal law. So I think of international criminal law as a discipline as being in a rather healthy state. There are lots of people doing it. There are lots of people asking really important questions about it. and students seem spectacularly engaged in the field. So this is a moment and cause for some celebration. But it's also, and Barrie picks up on some of this, a bit of a law of disappointment. People come to it with very, very heady expectations and come away disappointed. And sometimes when I'm giving talks on international criminal law, I think I'm supplying disappointment to the audience. Because I'm describing, in some cases, the sort of disappointment or disaffection Hannah Arendt experiences. So Arendt's visit to Jerusalem in 1961-62 to write her New Yorker pieces on Eichmann is the sort of avatar, if you like, of this idea of disappointment. She goes with all these excited expectations of justice being delivered, but then she leaves feeling the whole thing has been abnormal and disorienting. And thank goodness it was. Otherwise, we wouldn't have got Eichmann in Jerusalem, the book. We would have got some celebratory text that no one would be reading anymore. Instead, we've got this book that's situated as a kind of origin of one sort of way of doing international criminal law. But I think Arendt's response to international criminal law is a bit like the response of many victims. It's the response of the disenchanted or the chastened, the person who comes with expectations that are perhaps a little bit too high. And again, I think Barrie's book performs the admirable task of, in a way, asking us to both lower and heighten our expectations at the same time, but in different directions. And then I think his work also belongs in a kind of Wendy Brown tradition. So he actually quotes me at one point saying exactly the opposite of what I'm about to say now, but so what? Apparently, I once said international criminal law is probably best defined by what it cannot do, by what it is prevented from doing, and by what it refuses to do. Well, that has a certain stirring quality, I have to say, as an epigram. But I'm more inclined to think that international criminal law is defined by what it does do. So Wendy Brown asked us to think not about human rights failings as a field of endeavor, but rather its successes. To think about what sort of possibilities are enacted through these two fields? What sort of possibilities are closed off? What is it about the power of these fields as practices and languages that allows them to act on the world in the way they do? And so it's rather important to be attentive to that, to stop going on about international criminal law's gaps or its selectivity, or its failures, or its landscape of impunity dotted with the odd act of anti-impunity, and instead to think about what a powerful language it has become since 1918 and 1919, and to meet it on those terms. So that's I think the important direction, or an important direction we can take with this field. And then finally, there's a question of the defense of international criminal law. I've said somewhere else that those who sort of defend international criminal law are a bit like the UN in the Korean War defending the Pusan Peninsula. They've been pushed back by the North Korean forces so far, the North Korean forces in this case being the critics of international criminal law, that they found themselves defending this tiny peninsula, just holding out and no more. And in a way, the peninsula of international criminal law is to say, okay, we accept all the criticisms. I mean, Fred McGray has said international law basically is its own critical enterprise now. Everyone is a critic of international criminal law. And the response to its very obvious so-called failures, the failure not to prosecute everyone all at once, all the time, is to say that we should take a more limited view of what it does and what it ought to do. And one of the things it seems to be able to do is engage in a form of expressivism. This is the peninsula that we're defending now. The idea that it can have a symbolic impact on the world, and it can express certain values, and that this expressivism in Barrie's hands becomes a sort of strategic expressivism, which I found really interesting and curious in his book. I'll say something about that in a second, and I am going to finish very soon too. So he talks about the different histories that international tribunals enact, and he's already described that. I won't re-describe them, except to say one or two things about each one of them very, very briefly. These apologetic histories, I think that's right. I think at different times, international criminal law has produced an apologetic history of the world. Maybe Nuremberg and Tokyo were early examples of that. And maybe the split between safe and unsafe tribunals are also part of this story. Safe tribunals producing more apologetic histories than unsafe tribunals. I borrow this safe and unsafe idea from Rob Cryer, who is one of the editors of the series in which this book appears, and who is, you know, greatly missed in the field. And then the second history is these idea of spectacular histories. Christina Schwobel has written, of course, on this recently, and the idea that international criminal law's task in the world, or one of the effects it has in the world, is to somehow distribute genres of violence, and it has an aesthetic bias in the direction of spectacular violence and against forms of slow or structural violence. It could be that we're asking international criminal law to do too much to take on slow violence or structural violence. It's already blamed for all sorts of other things. Why blame it for this as well? But I would just say in relation to this that there's this new project on ecocide, which seems to sort of fit both in the slow and spectacular violence aspect of this. And I'd be curious to hear Barrie or Larissa's views on this. And then his idea of narrow violence. I've always felt that international criminal law or international, you know, legislation or treaty law in the international criminal law field begins with a very sort of expansive promise, and then often devolves into something much narrower. So the Australian War Crimes Amendment Act of the late 1980s is a good example of this. You know, it promises to sort of end impunity everywhere all at once for everyone, but only between 1939 and 1945 in Eastern and Western Europe. So it does that kind of temporal and territorial limitation that international criminal law often does. And Barrie calls this a sort of, I think, geographical narrowing at some point. But it's not all bad. And Barrie points out that international criminal courts can do very interesting work in relation to, say, the production of dissenting judgments, the idea of strategies of rupture pursued in different trials. I always think of the Barrie trial when one thinks about the strategy of rupture of the defense there, or in the way it sort of displaces power or shifts the lens. I mean, reading the transcripts of the Milosevic trial offers you a really quite refreshingly different view of what was going on in the former Yugoslavia at that time. And again, as Rob Cryer said, courts just keep certain things in the public eye. And then to go back finally to strategic expressivism, we can see the way that works in the activities of the GLAN network in relation to alleged crimes against humanity arising out of Australia's asylum policy. I mean, I was somewhat involved at the margins of that, and then I went to Australia and arrived at various dinner parties and was told that I'd accused several people at the dinner party of committing crimes against humanity. So there is something about that I regard as sort of theatrically important or expressively important, to put it into Barrie's language. I have lots of questions, but in fact, I in a way, I asked Barrie these questions in the Viva, and I think I won't ask them again unless the occasion arises in the discussion. But I think in the end, what Barrie's book has done, it's done lots of things. One of the things it's done is and I'm sort of partly quoting him, is it allows us a wider a wider horizon of possibilities for this field that we're all secretly in love with.
Thank you very much. And then we will go on with the reflection of Larissa van den Herrik.
Yes, thanks very much. Thanks, Barrie, for inviting me to this book launch. Of course, when I read the book and prepared for this launch, I also remembered that a very long time ago, when actually you had your first course on international criminal law. In a way, I had my first course on international criminal law too. You know, it was one of the first courses I taught when I came in Leiden after I finished my PhD. So it was a first for both of us. And even if it's quite some time ago, I remember it quite vividly, you sitting there with your friend Sahib Singh, asking all kinds of intricate questions. So I think it's really nice that we're here now today. And I'm also very happy that you are now my colleague here in Leiden. I think it's really great for me, for us at the Grotius Center, but also for the students at Leiden University to be taught by someone like you. I think it's a fantastic book that you have written, but also, you know, you have already in a way moved on. It maybe took you 3 years to write a book, but in the end, you did write a lot of other articles on different topics, cyber, election interference. So I think you're really quite an impressive scholar. So I'm happy to have you as a colleague for that reason, but also because of your spirit and the enthusiasm and the kind of scholar that you bring. And, you know, the other day, I think on Twitter, you launched you shared your course outline on the course. And I think it was a great course, but I think this spirit of sharing is very much you. And I think it's very much a spirit that we need in academia. So the book, even though, of course, it deals with international criminal law and a very serious topic, but I think this positive and dedicated attitude comes through. And even the series editors in their preface, they note that. They write, Dr. Sanders is not merely a passive diagnostician of international criminal justice maladies, but he also seeks to palliate, if not to cure them. And I think somehow this corresponds with what Jerry just said about you being a friendly author. So not just critical, but also, as the editors say, cautiously optimistic. And you look at the workings of the criminal courts within, and I quote the editors, but also Gary, within the wider horizon of possibility. So I think that says very much about you as a person and a scholar. So, you know, taking this idea of a friendly critic one step further, since we are here in The Hague, of course, when you read the book, there is this question of what should we do with this? What should be the takeaway from this? And, you know, from those who believe in international criminal law, and also for the practitioners in The Hague, what can they learn from your book, and what should be the takeaways? And so I have a few questions for you in this spirit. So firstly, the entry point of the book is, as you just also discussed, is that you say, I don't want to go too much into the question whether international courts should do history and to what extent they should engage with history. The fact is that they do. And so you want to understand how they do and, you know, what are the factors that shape the histories of the courts and that the courts produce. So you do highlight, you know, that there are two schools of thought. You call them the adjudicative conception of the historical function of criminal courts that focus more on the accused and on the fact, you know, that there should not be so much attention or space for grand histories, versus the socio-political conception of the historical function of criminal courts that look not only at the accused, but that have broader audience, that are very much aware of the broader audience, and that are, you know, more open to engaging with history and to producing history. So in a way, you say, you know, those are maybe extremes, and you don't want to take a position because you want to understand more, as I said, how history is produced. But then at the end of the book, when you talk about ways forward, you do emphasize that we need to be modest, and we need to manage our expectations. So is that not in the end then also a position more in line with this adjudicative conception, more saying international courts should not, and even if they do, but they should not be focused on history, and they should try to reduce it in a way. So, like, if you are a judge at the International Criminal Court, you know, how can you be modest in this way, or is it just a modesty of the audience? Should the audience be modest, or should judges also have a position in this, or the other actors? So then I have a question on this other notion that you bring forward on narrative pluralism, and also on judgments as a beginning of the discourse rather than an end point. And I think that, you know, I think from an historical perspective, or maybe from a perspective of the historical discipline, this idea that, you know, there is no endpoint to history, and multiple perspectives, contestation, I think that's very much at the heart of that discipline. But of course, if we look at law is about finality, law is about certainty, and even if those are just constructs or myths, there is a question whether, as a lawyer, we should not somehow try to preserve some of those myths. So if you talk about narrative pluralism beyond the courtroom, I can see space there. But as lawyers, can you elaborate still a little bit on whether we should desire narrative pluralism, where it should really create space for that? Maybe it is a fact, and maybe you should see it as that, but should we, as international lawyers, still aim to reduce narrative pluralism because that somehow goes with the idea of law, or not? Then one of the ways forward that you propose at the end of the book is actually to look sideways. So to not only focus so much on international criminal courts, but to understand, to appreciate that there are also other mechanisms that can somehow complement and come in to complement, you know, the historical discussions. But of course, the problem, I think, is that international criminal courts and international criminal concepts are very dominant. So they don't leave generally so much room for other mechanisms, you know. So maybe we can look diagonally down to others, but international criminal courts have this tendency to dominate. Concepts like genocide have this tendency to dominate, and that's maybe not so much in the court, it's in us. We are drawn to these concepts in a very intense way, I think. So two final questions really on the kinds of histories that international criminal courts produce. So they produce, you said, in a way, narrow histories, in particular also because they zero in so much on individual agency. And so in the book also you present Nuremberg as a reaction in a way to the failings of the collective responsibility in Versailles. And so the question is, have we not swung too much into the other direction with this focus on individual agency? So what can we learn from you? Should we not consider broadening the spectrum there? You refer to, for instance, the Malabo Protocol and the idea of corporate responsibility. So is it too narrow, the history, or is it just narrow? Is a question that I would have. And of course, the same goes for, you know, the focus that you identify on military leaders and political leaders, and leaving out business leaders. So the other day I was at the a PhD defense of Nikola Haydn, very interesting Serbian scholar on aggression. And he makes this point that the leadership requirement of aggression should be interpreted in a much broader sense, also to include business leaders. So should we move there to open up space to provide for broader histories, or not? So I know that this more your book was more about describing how it is, but yeah, maybe you can still share that with us. And then the last question really is also about the types of histories that are being produced. And then so you talked about narrow history, but also spectacular history. So really focusing on immediate violence. And, you know, I think quite interestingly in the book, you describe how we started with Nuremberg with this aggressive paradigm, as you call it. So a focus on aggression and on the initiation of violence, actually. But then with the move to the International Criminal Tribunals, we also moved to a atrocity paradigm that looks more at the violence that's being committed during a conflict, but not so much to the initiation of a conflict. And of course, now we have the crime of aggression that remedies that perhaps a bit, but still in relation to internal situations, we do not have that. And I think particularly in the case of Rwanda, it's very clear that was out of the spectrum. So also there, my question would be, can you reflect on that? Should we, as scholars or as other external actors, strive towards broadening the horizon? And you know, if you look at the situation now, for instance, in Afghanistan, in Ethiopia, you see that there's a starting point where there is a failure to negotiate, a failure to share power, a failure, and that is in a way those decisions lead to a certain type of mass atrocity. So should we not extend the spectrum back to the initiation phase of international criminal law, also with a view to broaden the horizon in a way? So yeah, I think you can see that your book gave rise to all these questions that I have. I'm not sure if you can answer them all, but then I'm sure that we'll have time later on. But thanks very much, Barrie, for writing this great book. And I think we have a lot of students here, but I think it would be very good, you know, if you start international criminal law, to read this book first, because then I think you have an entry point of appropriate expectations. Yeah, so thanks very much.
Thank you very much for that reflection. I think we've had two very interesting reflections, and then I would like to hand the floor back to Barrie for a response to them.
Thank you. And thank you so much for all of those reflections. My word, that was a lot of reflections and really interesting. I'm really, really grateful for such thoughtful engagement and also such kind words in general. Okay, so let's just jump in. I'll try to be fairly brief because I don't want to take all the time that we've got here. I think one of the themes that was mentioned by Gary was this idea of expectations and aspirations. And I think it was someone from Amnesty International who was telling me that actually there's now something that's going around NGOs that we need to manage expectations about managing expectations in international criminal justice, right? It's come to the stage now where the language of managing expectations, the language of modesty, which appears at the end of my book, has become a kind of, that's also becoming quite a dominant language, I think. That message is definitely come through. So I think it's interesting because if you look at the kind of early 90s phase, the kind of, rebuilding, rejuvenation period for the institutionalization of international criminal justice, there were a lot of these grand claims. There was a kind of romanticism around international criminal law, but maybe that was also just to get the field going, right? And you needed to kind of promise a lot to actually, people forget, I guess, that, it wasn't inevitable that this whole thing would get going. You needed to kind of promise states that these institutions would actually do a lot of different things to actually get them funded and to actually get them up and running. And then, obviously when they were up and running, they couldn't meet the weight of those romantic ideals that were put forward. But maybe that was never the point of those who were advocating them. Maybe it was just to actually get something rather than nothing. So that's just, I guess, a reflection on that. And then, Gary talks about, mentioned about my reflections on how, expressivism has become, centered. I think it's becoming more and more centered in the discourse on international criminal justice, and how we need to think also about, there are positive implications that come out of the expressive dimensions of international criminal justice, and not just in the narrow sense for, it's important that there are victims who do actually have their day in court and actually do have some sense of justice from these processes, but also, the documents that are produced, the narratives that are produced can be utilized, repurposed in all kinds of ways. And actually, there's a really interesting piece in the Third World Approaches to International Law Review by Alice Panapinto, which looks at the ICC prosecutors' closing of the preliminary examination in the UK-Iraq situation, and talks about how actually, if you look at the documents produced by the prosecutor, there's a lot there that can actually be used by activists, that can actually be repurposed in different fora, both whether it be art or whether it be domestic cases or domestic advocacy. And I do think there is a lot of creativity to be had in that space of thinking about positive uses of the language of international criminal justice. But there is always a but, right? The fact is that, when these interventions are made in particular countries, it can have not just expressive consequences, but it can be utilized in ways that legitimate, real consequences on the ground. I know Adam Branch has done really important work revealing how, the Ugandan government was able to and Sarah Nouwen rely on the kind of intervention by the ICC to kind of legitimize its military incursions in certain military operations. Now, I'm not saying those military operations wouldn't necessarily have happened without the ICC's intervention, but we need to also be aware that, expressivism works in all different kinds of ways, right? And so that's one of the major risks of this particular language, is that it can be co-opted in ways which are, not emancipatory, the opposite, in fact. And, you mentioned ecocide. I'm just going to be promoting other people's work because why not? But I think it's useful. The definition that came out with ecocide, there's been a lot of talk about this requirement in the definition of that the acts committed are either unlawful or wanton acts that cause environmental damage. And this idea of wantonness in ecocide, meaning the reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. This is a good example of, I think, of where expressivism may be negative, because there's been a really interesting paper by, if I can get the name, Liana Minkova, and she's talked about how actually this definition of wantonness and ecocide actually creates the impression that there is this separation between human communities and their environment, and that actually some kinds of severe and widespread or long-term degradation of the environment is okay, provided it has sufficient societal benefits. So there, I think we can see this kind of expressivism in action, right? On the one hand, isn't it a good thing to criminalize, severe environmental damage? But on the other hand, actually, the way you do that could have expressive consequences which are maybe not emancipatory. Then to Larissa's questions. So your first question was on the distinction that I make between adjudicative and socio-political histories, and whether in sort of this call for modesty at the end of the book, am I kind of taking a position in relation to those two? And I don't think I am necessarily, because I think really what I'm trying to call for there is that I think, as you said, it's the audience really, that's the audience, or I guess also the participants in a sense, but it's more on the expectations that whichever position you take, whether it's adjudicative or socio-political, there are going to be limits on the histories that are produced by international criminal justice. And so I think we, as participants, we're all participants in a sense, aren't we, in this enterprise, this field. We need to be wary of grand claims. And I think we are, actually, because, as I was writing the book, as I said at the beginning, there was the tides were turning as I was writing the PhD, right? And by the time the book's come out, which is this year, I really feel that this message, has been delivered, so to speak. In terms of your next question was Oh yeah, this is a really interesting question about, as lawyers, should we preserve the myth of finality rather than, accepting this pluralism? And I can see the lure of that, but I think the major point that I want to make, and there's a quote by Hayden White, whose work I rely on in the kind of theory sections of the book, which I think is really important because to recognize the constructed nature of judicial narratives and to recognize plurality, I argue, is not to be equated with the idea that there are no criteria available for judging the plausibility of different narratives, okay? So we can recognize that there are different ways of looking at things, but that doesn't mean they're all equally plausible necessarily. And Hayden White, a very critical scholar himself, says, the important distinction is not between ideology and objectivity, but between ideological constructions of history that are more or less open about the constructed nature of their versions of history and more or less willing to make their own modes of production elements of their contents. If postmodern notions of history are informed by a critique of the ideology of objectivism, this does not necessarily mean they are opposed to the truth and committed to lie, delusion, fantasy, or fiction. It means rather that postmodernism recognizes that reality is always as much constructed in discourse as it is discovered in the historical record, which means that postmodernist objectivity is aware of its own constructed nature and makes this work of construction the subject of its discourse. So what I understand from Hayden White there is that there are criteria to critique different narratives, and certain narratives will become dominant narratives in any given period of time, and that's fine. But really, we need to be aware of the constructed nature of these narratives. And I don't think that lawyers necessarily have to hide behind that. In fact, lawyers know this clearly, right? Because when you're an advocate in a courtroom, you know you're constructing a perspective for a particular client, for a particular side of the story. So I don't think it's even necessarily that controversial to acknowledge this. Third point, looking sideways, does international criminal law need to cede more space? And I think this links in actually with your two other points. So I'm going to try and take them collectively to create more space for discussion, which is that I agree. I think you sort of really defined it well in that third question, that international criminal law doesn't always offer space for other vocabularies, for other values, for other perspectives. And that's a choice, right? When International Criminal Court prosecutor says, considerations of peace are for the Security Council, that's a choice, right? That doesn't have to be how international criminal law is defined or how an institution like International Criminal Court is defined. And so one of my points is that international criminal law is not the only game in town in terms of a vocabulary for change. And rather than necessarily trying to pack international criminal law with more and more and more, what I've come to realize is that actually at base, international criminal law is beholden to states. Okay, it's beholden to the balance of power between and within states. And it's very difficult to get over that limitation. That is the kind of overarching limitation of this vocabulary, at least as it applies in international criminal institutions. And so unless this vocabulary is exported to other spaces, and that's fine, we can talk about that, then I think it may be about investing less in international criminal law, defunding. I was reading a paper by Nicola Palmer today, but defunding international criminal law, and maybe investing in other vocabularies and other routes. And I guess that's what I mean really when I talk about widen the horizons of possibility, not necessarily in respect to international criminal law, but in thinking broader, maybe thinking of international criminal law having less of a role in solving some of society's challenges. Thank you.
Thank you very much for the response to the reflections. And then there's now room for the audience also to share the reflections and questions. And to start, I see a raised hand by Joe Bowderly.
Thank you so much. Apologies for the odd lighting. I'm not currently being held hostage anywhere. There's no need to be alarmed. Thanks, Barrie, and the panel for a really interesting discussion. Congratulations on the publication of the book. I know it came out at the height of the pandemic, and while it would be lovely to be together in person for this, I think nonetheless this is a lovely event to have and a really worthwhile discussion. Some wonderful points brought up, a great set of presentations. I should mention that my day started 14 hours ago, so I may be in a fugue state, but I do have a question for you. It's around your idea of constructive narratives and of constructed historical narratives, which is central to the book. And maybe my question is quite prosaic or not particularly interesting, but I'm struck by the idea, or I'm interested in your thoughts around the impact of criminal procedure on the construction of historical narratives, the inherent adverse reality of international criminal proceedings must surely have a significant impact on the actual narrative that emerges from a trial. And I'm in particular interested in the fact that we're moving, and have been for quite some time, towards the development of general principles of international criminal procedure, also away from the notion that criminal procedure in an ICL context is something of a laissez-faire, in the hands of judges to decide through inherent powers and other rather invented notions to construct criminal procedure, towards a more punctilious approach to procedure. And I'm just wondering if you deal with this, if you address the impact this has on the construction of historical narratives. Thanks.
It's actually, I do talk about it in the book a little bit, but I kind of leave it to one side on the whole, because the focus of the book is really looking at legal categories and how they're interpreted and charged, and how, the politics over drafting of the statute, and how already, the narrative has already been written by deciding which crimes to actually include in the statute. That said, in discussing the framework that I mentioned earlier in my presentation, I do talk about some of the literature on sort of what I call evidentiary practices. And you're absolutely right. These are a key part of the story, even if they're not part of necessarily a central part of my particular story in this book. They do have a bearing. So, for example, story in terms of which evidence is admissible can have a huge impact on which essentially narratives are admissible into the courtroom. How evidence is presented and scrutinized, and Nancy Coombs has done really interesting work in showing how, depending on whether you adopt a more sort of adversarial or adversarial approach or a more civil law approach, can actually have an impact on how sort of, for example, witnesses respond to questioning. And all of these kind of micro practices in procedure absolutely can build up and have a really important impact on the trial. To take, let me think about, see if I can think of a simple example would be, even something as simple as, the prosecutor filing the charges late or not giving enough notice to the defense can lead to charges being excluded from a trial and that story not being told, right? And I think this, this has actually happened. So procedure and sort of rule-governed storytelling, I think, was a phrase that was used by one author, is absolutely a part of this story. And it's, frankly, the story of constructing history is incredibly complicated, and there are many kind of dimensions to it. I think another aspect that comes in there also is the aspect of culture, right? And so there's been some really important work done on, for example, the Special Court for Sierra Leone, which has shown how judges tried to sort of change the procedure, some of the procedures to accommodate certain cultural practices of Sierra Leonean witnesses. And I think, again, that's not work that I have looked into closely, but it is important work, and how culture is actually sort of navigated in these trials, which are obviously inherently, cross-cultural, will have an impact on the construction of narratives as well. So yeah, it's a really great point.
Thank you for the question as well as the answer. And then I see another raised hand by Fede Jong, so I give the floor to you.
Thank you very much. And Barrie, thank you so much for this really interesting presentation. I am looking forward to reading your book, as I'm working on a similar project at the moment. So this was really, really useful. And so actually what I'm doing for my project is actually look at the witness testimonies of some of the cases before the ICTY to look exactly the kind of narratives that are produced in those testimonies. And actually what I found is the three issues you had with apologetic history, spectacular histories, and narrow histories. It's very different in the court transcripts. I mean, you can look at it basically as a theater, right? It's like a stage where different narratives are presented and contested. And of course, you still have the grand histories. For example, Karadzic invoking the Ottoman Empire in his stories. But also very small histories of small acts of kindness or small acts of atrocities, actually. And so you have really a plurality of narratives. And what I even found is that there is sort of an interaction and interrogation of the United Nations through UN Pro Forum members as witnesses that you see almost nowhere else. And so I think more importance should be placed on the sort of the witness testimonies, on the process itself, because if you compare it to the judgment then becomes highly unpersonal and really quite cold. I can't think of the right word right now, but it reduces these really personal stories and these narratives to one narrative that is basically decided upon by three individuals who make up the chamber. I'm not saying the judgment is not super important. It is, but I think maybe more attention should be paid to the testimonies. And I wanted to hear your thoughts on this. Thank you.
Thank you. And I think it's a wonderful reflection. And I agree. I would agree with that. And I think, towards the end of the book, one of my sort of calls is that we need a greater critical contextualization of the judgments, because, the spotlight, and I think actually the spotlight is a term that Larissa uses in her work, right? It's shining a spotlight. The spotlight does tend to go on the judgment and the outcome of these trials, and that's natural. One can see why. But yeah, in a sense, there is a narrowing that takes place between the process and that finality of the judgment. And I think the more work that can be done to kind of surface and broaden the spotlight to the broader process, not just the witness testimonies, but all the documents as well that are going through the archive, that's really valuable work. But that, I guess, still doesn't get us away to some extent from the politics of these institutions. They're still witnesses from particular conflicts relating to particular defendants. And so we should also be aware of, how that's being framed, and that there is a distributional, there are distributional consequences that are occurring even there. So I think it's important, but we should also be aware of the wider distributive consequences.
Thank you very much, both. And then next raised hand is from Peter Vinci. I give you the floor.
Thank you very much. So my name is Peter Vinci. I'm a researcher at the International Red Cross Committee. Thank you all for very interesting and thought-provoking contributions. I am myself working on research related to the ICTY, so another ICTY researcher, but my research is related to the interpretation of political causes of crimes committed in the former Yugoslavia as interpreted in the ICTY judgments. So basically the political motive for the crimes to be committed. And right now I'm working on a case of Croatia in which there were two confirmed judgments on appeal. One judgment in the case of Milan Martic, which confirmed the OTP case theory that the Serbs were well, trying to create basically Greater Serbia, even if it was not phrased so. And the other one in the case of Šešelj, in which the chambers said that the Serbs were protecting themselves against aggressive Croatian nationalist politics and trying to preserve Yugoslavia. So, Barrie, I appreciate very much your narrative pluralism phrase, and I'm going to use it in my research and quote you, obviously, but I would call this narrative exclusion. And I don't know how as a historian, one can deal with it, because we have basically two mutually exclusive stories confirmed both on appeal at the ICTY. I don't know, anyone who wants to address this, I would be grateful. Thanks.
Thank you. I mean, I think that, you know, I guess the first question is whether there should be this expectation that these tribunals can reach historical forms of closure, right? This is where I reach at kind of the end of the book. You know, is that's probably too much of a burden for a criminal tribunal to bear, to have this idea of like, okay, we're going to, on all points, reach kind of historical closure. I think once we remove that expectation, then the fact that these different narratives emerge is not necessarily problematic. I mean, it could be problematic if it impacts, for example, on individual culpability in problematic ways. But it's not problematic in the sense of it enables those to continue the conversation beyond the courtroom and to interrogate those narratives and how they emerged and the important work which it sounds like you yourself are doing. And you know, maybe it's enough that these tribunals have done enough to actually preserve the documents and to enable that critical scrutiny to take place. Because, you know, there probably wouldn't even be the documents preserved if the institution hadn't existed in the first place, which is an interesting point to remember, I guess, as well. I don't know if Larissa or Gary had any thoughts on that and this idea of closure and expectations as well, but feel free, please, to jump in. No? Peter, yeah, please.
Well, yeah, I absolutely agree with you. I worked for the ICTY outreach for 9 years, and that was my main point for many, many groups that I spoke with. Do not have too high expectations. The tribunal is not a historical institute. However, in these some cases, the ICTY did take on itself, or actually the prosecution imposed the interpretation of a motive, which is not really required for establishing culpability, which is where they went directly into establishing grand histories. And my question is, if they did that and they came up with two completely opposing grand histories, should we not have them not do that in the first place? You know what I mean? I am taking here the position that you say you don't, but should we not avoid taking these tasks upon international criminal law if the results are so controversial? I can give you more examples, but I don't want to take the floor for too long. Thank you.
Yeah, I mean, I think, you know, it's certainly a case that can be made for a narrow approach, but I do think that it's interesting, and I don't have knowledge of, you know, the specifics of those cases, but it would be interesting to find out to what extent the motive of the prosecutor was driven by history, or the motive was driven by using a certain narrative because they just thought that was the best way, even if it was misguided, to get a conviction, right? Because I mean, a lot of the time, that could plausibly be a motive for writing a grander history if there isn't sufficient evidence to, you know, sort of directly link certain intentions to particular actors. And I think Richard Ashby Wilson has done some work on this idea of constructing monumental histories and the questions that you raise. But it would be interesting to find out, to what extent these actors are purposefully trying to kind of paint with a broader brush, or whether they are just using particular strategies because they think they are adjudicatively the best way of getting a conviction in a particular case. And I can't really speculate on that, but it is plausible to me.
Thank you very much to both. And then the next person raising their hand is Carolina Groot.
Hi, thank you for the event. I just had a quick question. I'm very, very new to the discipline, but I was just wondering, Barrie, when you're suggesting that we should be kind of doubling down in terms of expectations, whether you would be aligning with something as suggested by the Marska, where we should be, the court should be explicitly stating that it should be reducing its objectives because it's taking on too much, or whether it's something that could be done in a different way. Yeah, that was the question.
Yeah, it's an interesting question, and as I said, I think the way to manage expectations is a difficult one. How that's done in practice, and you do actually find in some of the judgments, and this is in the book in certain spaces, that actually the judges do try and expressly state, look, we are not a tribunal of history. Our findings here are really just for this case. It's for history to determine, the kind of wider validity of the narratives that are put forward. You do see this kind of express, attempt to limit their judicial function, which I think is quite interesting. But I guess in limiting expectations, it also comes through practices, through acknowledging that other processes, and this comes back to Larissa's question, that there are other societal mechanisms which maybe need more space in the conversation. Now, how we get to that point is not clear. Is it through prosecutors ceding more ground to different values beyond a kind of narrow promotion of criminal prosecution, criminal justice as justice? It's acknowledging that actually what justice means is much more plural and contested in lots of the contexts in which the ICC intervenes. Maybe through that kind of action or inaction, that would be, a way of reducing expectations as well, and setting out that there are more moments where the ICC should take a backseat and shouldn't be intervening, and allowing other processes to move to the front.
Can I just come in there on this question? I think what looks promising from an intellectual perspective might look problematic from the perspective of a defendant. So we will tend to celebrate sort of multiple narratives in our academic way, but defendants might feel themselves to have been badly treated in the face of those multiple narratives. So when we think about something like the wars in the Balkans in the 1990s, or indeed the First World War, we assume that there will be multiple historical narratives produced by historians. I mean, that is in effect history. Anyone who is interested in the origins of the Great War will have read 16 different accounts of those origins. Was it the train timetables? Was it inter-imperial rivalry? What on earth was going on? Was it because somebody was shot in Sarajevo? There are 16 historians and 17 theories when it comes to this. And it sounds as if that might also be attractive somehow in international criminal courts. That, say, in the early 2000s, when the Milosevic case was being decided at the ICTY, well, not in fact decided, but it was being heard at the ICTY, the ICJ was hearing the Bosnia-Serbia case, and the specter of fragmentation seemed to hover over the field for a bit. And of course, in the case of fragmentation, the fragmentation of legal norms, the fragmentation of institutions, and the fragmentation of historical narratives, two positions tended to be taken, even on the ILC to a certain extent, in its study on fragmentation. One was just to celebrate the fact that there were multiple flowers blooming in this particular field. And the other was to call for some sort of certainty in the law, or at least some stability in legal propositions. And I think that will partly depend on the sort of temperament one has as a lawyer. I mean, there's also res judicata, and the idea that narratives can be stabilized by courts by reference to factual matrix from a previous decision. It's not as if the ICJ or the ICTY has to relitigate every single history. There is the possibility of just accepting a particular history. But this problem goes way back, as Carolina knows from my class this morning. This question goes way back to the Commission on the Authorship of the War in 1918, 1919, which worried greatly about the prospects of lawyers and judges managing to produce any sort of authoritative history, because they simply weren't trained to do it, and that there were probably, as the Commission put it, multiple causes of the Great War. So in fact, this whole idea of a commission on the responsibility of the authors of the war, which goes back to 1918, 1919, begins with that commission saying, what if wars are not authored? You know, what if we've gone down the wrong track here? Or at least, what if there aren't single origins to this? But yeah, I've actually got into trouble. Just to go back to a point that was made earlier. I've been accused of calling for the abolition of international criminal law altogether. In a meeting in Berlin last year, this issue came up. I don't actually remember saying that, but then I decided I'd defend that proposition. And I think we can certainly afford to think of a world without international criminal courts, because after all, that's the world we grew up with. The world of international criminal courts is a recent invention. And I think one thing we need to be attentive to, which goes to your point, Barrie, about alternatives, is what's lost by doing these things through international criminal tribunals rather than in literature or drama or truth commissions or lustration or purging or assassination or declaration, or sanctions. There are 1,000 different ways of approaching a particular problem of, mass atrocity or individual criminality. And I guess I would end by saying, I don't know if we do want to get beyond sovereignty. You mentioned this at one point, and this again goes back to something Rob Cryer wrote about, the relationship between international criminal law and sovereignty, and the apparent opposition between the two. But I think, as you pointed out, is it really an opposition? And you seem to say it wasn't. But the question about whether it should be an opposition is an even deeper question. And what I worry about is that the humanity that arises, or the international community that arises in the place of multiple sovereigns and all the problems they cause for international criminal law, might be even more frightening and totalitarian than the present rather mixed picture.
Can I just add on this very briefly, Barrie? Yeah, just a very brief point. I do think that if we talk about the point that Gary made at the beginning I think it's an important point to make. If we talk about criminal law, there are certain limits that come with that idea. I don't know. Well, I don't want to say that you made that point, but I do think that, we are talking about convicting individuals and sending them to prison. So there is a certain limit to revisiting the facts that you used to sentence someone. I do think there are certain, and of course, even if there are constructions and beyond reasonable doubt is applied in different ways, I do think there's something in the core of criminal law that we also need to preserve. And if we are too open to plurality somehow, at some point, I think there is a tension with that core of the notion of criminal law. But I also think, and then a short point is that the point that Faye made on history. Of course, we talk about history as if that is something, but there's the grand history of who started the war or what happened, but then there are also the small histories, the personal histories, and so I think there are also different layers there, and so I think the work, for instance, that Faye is doing on spotlighting the witness testimonies that do not make it to the judgment for obvious reasons, precisely because of the strictures of criminal law, is in a way another way of looking sideways, even within the setting of the tribunal. So I think that's a very creative way of looking sideways. We just need to look sideways in different ways than just looking aside or so. Thanks.
Thank you very much for that discussion. Are there any other questions from the audience or other reflections on what has been said before? I don't see any questions for now, and we're also at a bit of the end of the book launch, and therefore I would really like to congratulate Barrie from Out Justitia and really thank him for including us in this event and including and making sure that it's also open to us students to see this discussion between scholars that we are reading about. Yeah, very lot of thanks for including us.
And thank you, Yasmine, for excellent sharing today. And I just want to thank everyone. I want to thank the discussants, Gary and Larissa, and I want to thank all of you for coming to listen to this discussion. I really appreciate it. It means a lot. And if you enjoyed it, maybe, go to the library and have a flick through the book. Who knows? But no, really, thank you so much for coming. It was a real pleasure. And feel free to reach out. I hope to see those of you who are my students in the classroom soon. Thank you.